How you doing, Mr. Dillon? Joe Dillon?
Good morning, Your Honor, or good afternoon. We're here on a state grand jury bond hearing. This is State of South Carolina versus Curtis Edward Smith, 22 GS 4710. Mr. Smith is present and represented by his counsel, Jarrett Bouchette. He has currently been indicted on June 23rd, 2022, just unsealed not too long ago, for 12 counts. Your Honor, we have criminal conspiracy, which is 0 to 5 years, and fine up to $5,000. We have 4 counts of money laundering, $100,000 or more. Each one of those is up to 20 years and a fine of up to $250,000. He has 3 counts of forgery, 2 are $10,000 or more, and 1 is $10,000 or less. The 2 $10,000 or more are 0 to 10, and the $10,000 or less is 0 to 5. He has a distribution of Schedule II narcotics by conspiracy. That's up to 2 years. There is a trafficking methamphetamine charge, 10 to 28, Your Honor. That's of course 85% time, and that is a mandatory minimum of 3 years up to 10 years, and a fine of $25,000. There's possession of a Schedule II controlled substance, which is 0 to 6 months, as well as a possession of marijuana. All in total, we have anywhere from 3 to 122 years and 7 months at issue with these offenses, and over $1 million in fines.
Nelson.
Please, Court, Your Honor. My client is 62 years old. He has no felony criminal record. I think it's safe to say he's entitled to a bond under the statute. And, Your Honor, I don't have to educate the court on what our statute says, but it certainly has a strong presumption in favor not only of bond, but of a PR bond. This is a non-capital case.
Strong presumption in favor of a PR bond?
Yes, sir. And, Your Honor, in this case, there is no risk of flight. The Attorney General's office, law enforcement has, we've been cooperating with. They've known where he's at over the last better part of a year. He's lived in South Carolina, down in Colleton County his whole life. Ties to the community are strong. Your Honor, if he was a flight risk, he would have left the jurisdiction before now. So I don't think there's any evidence to indicate that he is a flight risk. And with regard to danger to the community, like I said, no record, nothing to indicate any danger to any third parties. Your Honor, even with regard to the trafficking count, which is classified as a violent offense, Your Honor, that this case does not have the hallmarks that one might look at in terms of being concerned for bond. There's no allegations of guns, gang involvement, anything of that nature. So this is strictly a drug allegation. So under those circumstances, we think he's entitled to a PR bond. But should the court disagree with us, we think only a reasonable bond would be necessary to ensure his appearance at trial. Like I said, I've been representing him now since, I believe it was September or October of last year. We've been in communication with Mr. Waters and with law enforcement throughout that time. So nothing is, he knows what he's going to have to answer and when he's going to have to answer it. Some of that's still to be determined, but only a small amount, I would suggest no more than $50,000 would be necessary to ensure his appearance for court. The other thing I would point out is, number one, I forwarded to Your Honor prior to court beginning this morning an affidavit from Mr. Smith's doctor, and I apologize I don't have a printed version. I didn't have it in hand before I left the beach this morning, but that affidavit outlines the ongoing treatment that Mr. Smith has been having and would continue to require regarding his pain from prior back injuries. So I'd be very concerned that he wouldn't be able to receive the level of treatment that he needs in a pretrial incarceration. The other thing, Judge, this is obviously a state grand jury case. These cases involve much more discovery than would be involved in most state court cases. Obviously, I would need to be able to ideally have him come to my office, review that discovery in preparation for the trial. That certainly is much more difficult in the county jail. And
tell me about the medical problem that you referenced.
Your Honor, the diagnosis, I understand the affidavit was classified as a failed back condition, and I can pull it up here so I can speak a little bit more accurately. Your Honor, this is the affidavit from Dr. Johnson with MUSC. He indicates that Mr. Smith has a failed back syndrome and a psoriatic joint arthritis. He had performed 2 procedures over the last 7 months on Mr. Smith, that he has ongoing treatment for the pain, which is substantial. He indicates that the ongoing treatment, as well as the, I'm using his terminology here, intermittent interventional pain injections would be critical to keeping him from being in what he classifies as unbearable pain. So that is substantial, and that's the extent of my knowledge of his medical condition. And that treatment comes from a substantial back injury he had a number of years ago. So I don't anticipate any major surgery, but that ongoing pain management is something that is going to be needed based on the doctor's opinion. So,
What treatment has he had in the past 3 years, not within the last 7 months? But would the last 7 months been prior, subsequent to these charges?
Your Honor, he was indicted and charged, of course, with things related to the side of the road incident at Old Salkehatchie Road. He's currently out on bond for 2 drug offenses, as well as for presenting a firearm, false statement in relation to insurance, conspiracy, assisted suicide, and abhand for a total, I think he had $55K of surety bonds there. He got out on bond. Obviously, he's been out for the past 7 months during that period of time. At the appropriate time, I can detail the facts of the current indictments for Your Honor.
This treatment has arisen after release on bond.
well, at least with regard to that doctor, Your Honor, and I apologize, I'm not familiar that you've been receiving treatment.
Johnson at Southeast Spine. I got it.
My understanding, he's had been receiving treatment prior to that, but his current doctor was the one that he's been starting since last year or so.
Trying some new programs, Your Honor.
Sir?
We're trying some new methods to try to help me. I'm missing 3 discs in my back, a back break in 2007 in Logging Woods, and I have titanium rods and screws in my back also.
So like I said, so they've begun a new course of treatment here recently, and that's why it started with this particular provider. Your Honor, to the extent that Mr. Waters has referenced the roadside shooting incident, again, just for emphasis, this is not a situation where he's out on bond for one set of charges, commits further criminal acts while he's out on bond. These allegations and this indictment basically predate that incident, and moreover, I believe this indictment incorporates almost all the charges, at least 2 of the charges from that roadside shooting incident, which he's already posted bond for, and of which that bond amount was calculated based on those additional charges. The remaining charges that the state chose not to incorporate into this indictment, they rely almost solely, if not solely, on the version of events and the testimony of Mr. Murdoch, which at the time that occurred, not as much was known as it is now. And we've finally had a chance
You're
to...
referring to the previous charges?
That's correct, Your Honor, the roadside shooting incident. And so they've taken 2 of those charges, brought them in with this indictment, left the other ones sitting in the General Sessions Court in Hampton County. And so after reviewing that, we anticipate filing a motion for speedy trial on those charges, because that case and the allegations arising out of that incident, like I said, they rely 100% on the testimony of Mr. Murdoch. So we're not here to try that case, but just to make the court aware of where we stand on that.
Your Honor,
Yes, sir.
just to clean that up just a little bit, he was initially charged in September for charges related to the side of the road. That would be the ab-hand, the pointing and presenting, the insurance fraud, the conspiracy. Those charges have been indicted by the Hampton County grand jury and remain there. When a search warrant was performed at his house, drugs were uncovered, including methamphetamine and the pill. He was charged in Colleton County for those because that's where his residence is. However, the labs have since come back, and then those substantive offenses have been now indicted in the state grand jury. However, the weight, once those the substances recovered in his house and his outbuildings was analyzed, was over 10 grams, hence it arises to the level of trafficking. As we look at the underlying charges in Hampton, again, we're not here on a bond hearing on those, but I would dispute the notion that it's solely based on the word of Alec Murdaugh. There's a lot of law enforcement effort that went into that. But the indictments in this state grand jury indictment, aside from those 2 drug charges, are different, and they are the product of an extensive state grand jury investigation with evidence from multiple sources. The first charge, of course, is a criminal conspiracy, and at issue is over 437 checks that came from Alec Murdaugh to Eddie Smith from October 7th, 2013 to February 28th, 2021. Your Honor, those checks total almost $2.5 million, and the allegations are that was a conspiracy between Alec Murdaugh and Eddie Smith to essentially launder money to avoid the structuring, or to structure these transactions to avoid the currency transaction reporting and to evade detection as that money was cashed out from Mr. Murdaugh's accounts. After that, we have 4 counts of money laundering based on Mr. Smith's participation along with Alec Murdaugh in disposing of those checks, running them through various accounts, running them through associates, Mr. Smith forging the endorsements of various people in order to give the illusion that these were legitimate transactions, and that was done for the purpose of these various unlawful activities, including a long-standing conspiracy in which Mr. Smith was providing, distributing pills in large numbers to Mr. Murdaugh. For count 2, the amounts which were from May 25th, 2018 to May 24th, 2019, the reason why it starts there is because that's when the money laundering statute became effective. The amount for that period is $202,801.83. Going on to count 3, Your Honor, this would be from May 25th, 2019 to May 24th, 2020. And the money laundering statute expressly aggregates things in year periods. So for that amount, it would be $606,463.10. For count 4, this is May 25th, 2020 to February 28th, 2021. And the amount at issue there is $1,085,938.32. Count 5, and this would be from March 21st, 2021 to September 7th, 2021, and that would be $973,642.44. What we see around March is moving from March into June of 2021 and thereafter is an extreme acceleration of the amounts that Mr. Murdaugh is washing through the aid of Eddie Smith. The amounts increase vastly, and they no longer are paying attention to the structuring problem. Structuring meaning trying to do transactions under $10,000 and splitting them up so they cannot be detected. That stops. Your Honor, going on to count 6, this is over $280,000 in multiple checks of alleged forgery in which Mr. Smith forged the name of a family member without that person's consent or knowledge in order to wash these checks and participate in this alleged money laundering scheme. Count 7, this would be from August 2020 to February 2nd, 2021, and that's over $97,000 in forgery, where again he forged the name of a person close to him without that person's consent or knowledge in order to facilitate this alleged money laundering scheme. And then count 8, that's April 23rd to April 26th, that's the one that's less than $10,000. That was a single instrument also in which he allegedly forged the name of a person close to him on a check, and it was just at a different institution. That was sort of a one-off. After that, you again get to a historical distribution conspiracy of oxycodone pills, and that lasts from October 7th, 2013 through September 7th, 2021. And Your Honor, we allege, and the state alleges, and the investigation has revealed that a large portion or a substantial portion of all those millions of dollars did go to facilitate this oxycodone distribution network that Mr. Smith was a big part of, but not all of it. There is substantial evidence that money was cashed out through these transactions that Mr. Smith participated in. And so there was a substantial amount of cash unaccounted for that passed through Mr. Smith's hands. Then we do, of course, have the substantive drug offenses from Colleton County that I previously mentioned. Your Honor, Mr. Smith also has a prior record. He does have a 1985 receiving stolen goods. He got 3 years probation for that, and then had a 2002 simple assault and battery conviction as well. Your Honor, given these factors, given the amount of money that has gone through, given the depth and the long-standing nature of this particular scheme, given also, Your Honor, that when law enforcement went to apprehend Mr. Smith on Friday, they were sitting on my house for about 30 minutes and ultimately observed a lot of traffic going through there. When they went in to arrest Mr. Smith, there were a number of individuals explained to me as known to law enforcement as people that have had methamphetamine and property crime charges, including one individual who was arrested in the house because that individual had outstanding methamphetamine charges and also had a pistol in his pocket. That causes me great concern when we look at the amount of money that went through Mr. Smith's hands over the course of this alleged conspiracy, the people with whom he's associating, the fact that he had trafficking weight methamphetamine when his house was searched in September. And so all of those cause great concern. Also the severity of the charges and the weight of this particular matter. Given all of that, the state is requesting a surety bond of $350,000 for Mr. Smith, and we believe that that would be appropriate.
If I may just briefly reply, Your Honor.
Yes, sir.
On the first item, regarding the funds and the money that was referenced, it would be easy to presume, and I think what the state's insinuating is that, you know, Mr. Smith may have access to this money that had been cashed, withdrawn, etc. But the nature of the indictment itself alleges that it was laundered. It's the first page for Mr. Murdoch's benefit. That money was in fact funneled to Mr. Murdoch according to the state's own indictment. So I don't think we can operate on the presumption that Mr. Smith has sort of a stash of large chunks of money somewhere. And even if they did, the state's had almost a year to investigate and figure out where it was. So I think for purposes of today's bond hearing, there's no evidence that he has some large amounts of cash that would indicate a flight risk. Regarding the amount of the bond, Your Honor, I'm not appointed to represent Mr. Smith, but his only source of income is from from disability. I believe he would qualify for public defense under the Indigent Defense Program, and I think he would qualify as indigent. Now,
You've been retained?
yes, sir, I was retained earlier. I have not been formally retained on these new charges, but I anticipate to continue representing him on these new charges. But I do have...
What are you referring to when you talk about public defender?
Well, I only make reference for purposes of what his income is and a bond that would be reasonable in relation to his net worth and or his income to ensure his appearance. So that was the only point I was making with regard to his financial situation. So the other item is I've received nothing, been given nothing regarding this information about individuals at his house. I don't know if those folks, if Mr. Smith had any idea that there were outstanding warrants, what the nature of it was. If some officers want to take the stand and provide testimony as to what Mr. Smith knew and who they were and what evidence they have to substantiate that, that's fine. But other than that, we've got somebody that really has a minimal criminal record and, like I said, a very limited means. And you know, I'm very concerned that we could be in a situation where the state grand jury cases obviously take a very long time to resolve. The last one I just pled was time served to 5 years in a pretrial situation. So I don't know if it would take that long, but given his health, given everything else, a $300,000 bond would seem greatly excessive to me, Your Honor. And I don't think it would be necessary to ensure his appearance at trial, which again is the sole purpose of why we're here, not to try the case or to punish him pre-trial. So on that basis.
It's one of the components is assurance at trial.
Sure, absolutely.
It's one of the considerations.
Sure, absolutely.
Your Honor, very quickly, again, the allegations here are that Mr. Smith personally handled millions of dollars that was ultimately cashed out. Now, that's the nature of cash. Cash goes where it goes. But we do know for a fact that millions of dollars, at least 2.5, and frankly more than that, went through his hands. And just because of the fact that it can't be accounted for doesn't mean that it did not go through his hands. His involvement in this conspiracy is extensive and it's long-standing. And for that, the state is concerned about his risk of flight, is concerned about who he's associating with, and is certainly concerned about his appearance at trial. As far as the length of time, Your Honor, of course, is the state grand jury judge and also assigned to these matters. And if something needs to be addressed down the road, then that certainly can happen at the time. But I would not respectfully would say now's not the time to address the length because it just happened today.
I would just like to make one final proposal, if I may, Your Honor.
I have a proposal.
For the court's consideration, I would, if the court is inclined to grant a high or substantial bond, in lieu of that, as a court to consider perhaps a ankle monitor, because that would allow him to, one, continue getting his medical treatment. It would also alleviate the state's concerns that they brought today, which would mean, when you're on ankle monitor under the statute, you're essentially still in the custody of law enforcement, and they could search his house, they could do whatever would be necessary to ensure that whatever those concerns are not an issue.
I certainly have no objection to an ankle monitor, but I still think that needs to be in accordance with or in companionship with the high surety, not in lieu of. In addition, Your Honor is certainly well aware that the state grand jury bond form has a number of standard conditions that are usually part of those, which would be waiver or surrender of his passport, and no possession of firearms and things of that nature as well.
Mr. Smith, would you like to say anything regarding the bond?
Yes, sir, Young. I don't have any money. All the money that Mr. Waters talking about, Ellis Murray got all that. I didn't get none of it. I don't have any money. All I have is my disability I live off of, and that's it. I live in a modest house on a small piece of property. My automobiles are 10, 15 years old. I don't have any access to money like that. The people they were talking about at my house was renting a shop of mine I had back in the back there. He was doing some work in it. I don't know who all was in the shop back there at the time. I was in my house, whenever all this happened.
Anything else?
I'm not going anywhere, Your Honor. I look forward to clearing my name.
Nothing further, Your Honor.
Nothing further, Your Honor.
Given the nature of the allegations, the extensive period of time, the alleged criminal wrongdoing spanning over a period of 8 years or so, given the serious nature of the criminal allegations, particularly involving trafficking in seriously dangerous drugs. I note that where there is a claim that the person is merely a drug user, that doesn't reveal the true nature of the dangerousness where drug trafficking is involved. Because wherever there's drug trafficking, you have related crime, burglaries, robberies, many crimes generated thefts by people seeking to obtain drugs to feed their habits. I don't know all of your circumstances, Mr. Smith, given what has been presented and what is contained in these indictments. These are very serious crimes carrying very, very serious punishment. The total number of years of which Mr. Waters indicated is being
Your Honor, it's 122 years.
all matters were done consecutively. And how old are you now?
62 next week.
It was doubles your 62 years.
Yes, sir. Yeah, and all that stuff, I'm the one who got pulled into it, not by choice.
Nature of the indictments, these are not single count, single person indictments. These are indictments containing allegations of conspiracy between you and Mr. Murdoch. Everyone is presumed not guilty, and speedy trial, if requested, will be honored. The constitutional right to a speedy trial regarding a multitude of indictments, multitude of charges. Question of where do we start, pretty much, with all of these charges. Well, I certainly take very seriously all of these charges, because they're all serious charges. Trafficking is classified as a violent crime.
Yes, sir, Your Honor.
It's a serious crime, violent crime.
I understand that, but I didn't trap it.
For obvious reasons. I'm not trying to adjudicate guilt or innocence, but all of that must be considered in the issue of bond. And based on all that, I'm going to set a bond of $250,000, surety bond, and with the special condition, house arrest and ankle monitoring, should you post bond be released. Also, require that you be subjected to drug testing, periodic drug testing, and upon notification by the state, you shall appear for testing at a place or facility designated. Prohibited from having any contact with any co-defendants in the case. And GPS monitoring as well. Any other conditions requested?
No firearms, Your Honor. And obviously, we would request a waiver of extradition. I know you have the house arrest and GPS, but we would request that. I think you've covered those. And again, there are those standard conditions on the state grand jury bond form that includes, I believe, most of the ones you mentioned, Your Honor.
Bond is not posted, it can be reviewed within 60 days.
Thank you, Judge.
And Your Honor, so that 60-day review, would that be a de novo review?
Pardon?
If it's at a 60-day review, would that be a de novo review?
Yes, sir.
Okay.
Be a review, I don't know about the note review. Will be a review. Request within 60 days.
Very good. Thank you, Judge.
Thank you.
Thank you, Judge.